I see 2,500 new referrals a month from policyholders all across the country. And part of the things that I see are the top 10 mistakes that policyholders make. Number one, can the insurance company take away your policy based on a fraudulent misstatement? What does that mean? Take out your policy, look at the application at the back, and they're going to look at to see whether we told the truth. Did we materially misrepresent anything on the application? In some circumstances, you'll see language at the back of the policy that says, accept fraudulent misstatement. And that's where a carrier 5, 10, 15, 20 years can come back and contest what we said on the application. Most policyholders don't have a recollection, but I ask them to sit down with the application and go start to finish. Oftentimes the agent or the broker will have misheard, misunderstood, misrecorded, and that information is easily correctable. So, number one, the carrier is going to try and take away the policy for accept fraudulent misstatements. They can do that at any time, or they'll look at whether the policy is still contestable within the first 2 years. So make sure before you get ready to fill out a claim form, before you get ready to call for a claim form, that you've had some help going through that application. Second, pre-existing condition. If your carrier can't take away your policy, they're going to try and apply some pre-existing condition to limit their exposure. Most of the time, the language is clear as mud, and it's a Swiss cheese full of holes policy. So take a look at the pre-existing condition. It usually says in a health situation or disability that for the 12 months or 2 years or 5 years before you applied, that they're going to look at to see whether anything that you had before is similar to the claim that you're filing. It usually applies for 12 months or 2 years after the coverage goes into effect. And a lot of policyholders need help with that. So it's an important part, pre-existing condition. Third, big mistake. Policyholders don't understand the features, advantages, and benefits of their insurance. They know they bought a policy. They know they got a promise from the agent that it's supposed to work this way or that way. But most people haven't walked through the policy to look at the definitions. And I know it's difficult. It's very tricky and it's confusing. But you have to understand how to use your policy before you can actually sit down and make the claim. So at Darras Law, we do provide that free policy analysis, free policy help, because the definitions are difficult and they're tricky. So get some free help if you can. Number 4, carriers call at odd times. Usually, they're asking important claim-ending questions. Make sure you have a spiral notebook next to the telephone so you can record, you can memorialize, you can put down what you were asked and how you responded. Most of the time, we think it's unimportant. But if they deny your claim a year or 2 later, it's hard enough to remember what we had for breakfast last week, let alone the he said, she saids of the conversations with the carrier. So put that spiral notebook next to the telephone and keep your conversations brief. The important questions tell the carrier to put in writing so you can reflect on the question and you can give a full, complete, and honest answer when you're responding. Number 5, documents. It's one of the most difficult and cumbersome parts of insurance. Once they start asking for documents, it's a never enough situation. They want tax returns. They want claim forms filled out. They want a personal inventory if it's a property insurance case. They want medical records. They want an authorization. They want prescription medical. Some things you don't have to provide. Don't we all have a tax return privilege? Aren't our tax returns something that are confidential? That's the time that people need some help. And at Darras Law, we provide that free advice, claim help, claim questions, claim documentation, And that's a very important part of presenting a bulletproof claim. Remember, you're supposed to get fast, friendly, prompt, courteous service. How often do we get that? That's the covenant of good faith and fair dealing. Your insurance company is supposed to look at the claim with an eye towards payment. They're supposed to help, assist, facilitate, and deliver fast, friendly claim service. So when it comes to documents, be careful. Only give what you need to. Field visit, mistake number 6. The carrier writes and says, our field representative is going to be in the area. We want to get a better understanding face-to-face of your claim. Let's sit back and think about that for a second. You've submitted a claim form. In a disability case, your doctor submitted an attending physician statement. You've given them an authorization that allows them to go back to the time that you were born to get everything about you, occupationally, vocationally, medically, and now 6 months, a year into the claim, the carrier says, we need to better understand your claim with a field visit from one of our company representatives. That should send off a red flag alert. They're not out there trying to get a better understanding of your claim. What they want you to do is agree to have that interview in your home so that they can come out, assess your neighborhood, and if you live in a nice area and your Mercedes is parked out front, they can document in the claim file that the insured lives in a wealthy neighborhood. They can come into your house, look at your art, look at your surroundings, look at your office, see whether you've got a pager, a beeper, your telephone. What are you doing? I always say to people, on a field visit, they're not there to get a better understanding of your claim. They're there to talk about your neighborhood, your lifestyle, and what kind of car you're driving. They're out there to set up and assess the surveillance, because that's mistake number 7. A field visit is always accompanied by surveillance. What's that? In a disability case, the carrier is also trying to measure your activities that are inconsistent with your restrictions and limitations. So if you say, I can't bend, stoop, push, pull, carry, lift, I can't sit for very long, they're going to hire videotapers or the paparazzi to come out there and stake out your place. Remember, they've just had a field visit. They know your neighborhood. It'll be 1 car, 2 cars, and they'll be out in front of your property at 5:30 in the morning. They'll see where you go all day until the lights go out at 8 o'clock at night. So I always caution policyholders, don't use the word always and never. If you say, I never drive, and they get you driving, that is an activity inconsistent with your own restriction and limitation. If you say, I always use a cane, and you go to the doctor without a cane, I can't bend, lift, stoop, push, pull, carry, I always see my people in Costco. There are half 2 things that we need to do, even if we are disabled. We've got to eat, and the policy doesn't come with a personal shopper. We got to get to the doctor and get to the store to get our prescriptions and to put food on the table. The policy doesn't come with a chauffeur. So you be careful when it comes to surveillance. The carrier is going to spend a lot of time, a lot of energy to put people out there for 4, 5, 6, 8 days in a row, especially the holidays. Why? They want to see us putting up our Christmas tree lights. They want to see us hulking beach chairs down during the 4th of July. You be real careful with activities inconsistent with your disability, and never use the term always or never.